I'd been told that we had to wait for very technical problems to be ironed out, which is the reason for the delay, for which I apologize. It appears from the squawking noises we heard that they haven't all been sorted out, but I hope we won't have that again.
Ngiyaxolisa umhlali ngaphambili ngokuba kuthathe ixesha ukuthi bekho amagingxigingxi izinto ezithize bezisalungiswa.
Mr. Matabedi, I understand you're going to call the next witness. But before you do so,
Testing. Testing. Yes, Danny, can you hear Danny?
It sounds as if the sensible thing for us to do is to adjourn and come back when we receive an assurance that everything's been sorted out, because it's no good having this echo which makes it difficult to hear what's said. Well, I don't know if the problem's been sorted out. Has it been sorted out? Yes. All right. Okay, well, finally we're getting underway. As I've said, I apologize that we started late, but there were technical problems that persisted up to the very last minute that required solution.
Njengoba sisho umhlali ngaphambili okokuba siyaxolisanyana okokuba kubethe ixesha elide kangaka bekusalungiswa la magingxigingxi bekhona.
Mr. Matabedi, I understand you're going to call the next witness. But before you do so, I understand Mr. Mpofu wishes to say something.
Uzawuthetha umhlekazi Siminya kodwa umhlekazi Mpofu kukho into ethanda ukuyiveza.
Thank you very much, Chairperson.
I'm sorry to interrupt.
We don't need the witness on screen during this application.
Yes, there is a difficulty that, Chair, that witnesses on the screen, and I think it would be helpful if parties were reminded of your rulings in relation to disclosure of the identity of Mr. X.
Perhaps before Mr. Mpofu, I should read out to remind everybody the rulings that I made. When I considered the application for the evidence of Mr. X to be heard, firstly from a remote video, through a video link from a remote location, and secondly for us to sit in camera. The rulings I made were the following. One, that the evidence of Mr. X be presented in camera and by video link. Two, that at all times during the testimony of Mr. X, one of the evidence leaders should be present in the room from which he testifies. Three, that only the commissioners, the parties, the legal representatives, the evidence leaders, and accredited media representatives shall be present in the auditorium during the testimony of Mr. X.
Mr. X kuyaba ijaji ne-commissioners nabameli bonke amaqela nabo bonke abantu abanye ababandekanyekayo kulento lena apha kule holo sikuyo abanye abavunyelwe.
That at least 2 weeks prior to the commencement of the testimony of Mr. X, the SABC legal representatives shall A. disclose the name of Mr. X to the evidence leaders and the legal representatives of all the parties.
Kwanikwa okokuba iveke ezimbini phambi kokuba siqale namhla bonke abameli ke abameli amaqolo ohlukile banikezwe umfanekiso wale ndoda bakwazi ukuyibona.
B. Provide the evidence leaders and the legal representatives of the parties with a photograph of Mr. X.
Njengoba eshilo okokuba baxele ngubani lo muntu banikezwe nomfanekiso wakhe ifoto yakhe.
and C, indicate to the evidence leaders and the legal representatives of the parties all points at which they've been able to identify Mr. X on video footage of the events during the period 13 to 16 August 2012.
baxelele ke nezindawo apha zawuvela khona kwimfanekiso le yevidiyo zezehlakalo phaya kusuka ngomhla ka-13 kude kube mhla ka-16 ku-August unyaka ka-2012.
That the details in paragraphs 4A to C above shall be disclosed. This is paragraph 5. That the details in paragraphs 4A to C above shall be disclosed only to the commissioners, the evidence leaders, and to the legal representatives who require the information in order to obtain instructions from their clients.
La manqaku sithetha ngawo ke azawuvezwa kuphela kwiikhomishina nakuye umhlali ngaphambili nakumagqwetha abamele amaqela ohlukahlukile akwazi okokuba abonisane athethisane nabantu abo babamele.
That neither the name nor any information that may reveal the identity of Mr. X
kawukho bizo lakhe elizawuvezwa apha noma into ethize mhlawumbe inqaku elithize elingahle libonise esidlangalaleni okokuba ngubani lo mfo
shall be disclosed further by any party other than the SAPs, save for the purpose of obtaining instructions.
akukho mntu ke noma ngubani ngaphandle kwabo bemele ama-SAPS abanegunya lokwenje njalo.
7, that subject to the rulings made in paragraphs 4, 5, and 6 above, in terms of sections 18 and 19 of the Witness Protection Act 112 of 1998, the following shall be prohibited.
Kukho ke ngaphandle kwezi zinto esizivezile kuphansi komthetho lo wokhuselo lwamangqina owenziwe ngo-1998 limibandela elandelayo izawulandelwa nayo.
A, the publication of any information, including any drawing, picture, illustration, painting, photograph, pamphlet, poster, or other printed matter in whatever form,
anakuvezwa kumaphepha umfanekiso wakhe noma mhlawumbe into emdrowayo apho bonisa khona okokuba ngubani lento nento ingaveza nje okokuba ungumbani aziwe esidlangalaleni enqatyele loo nto,
which may disclose the place of safety or location where Mr. X is,
nokuthi ukhuselwe indawo phi kwangoku ayinawuvezwa,
or where he has been relocated in terms of the Act,
nokuthi xa esusiwe apho behlala khona amikiswe kwenye indawo ayifanelwanga ivezwe loo ndawo azawuthuthelwa kuyo,
the circumstances relating to his protection,
no meko akhuseleke phantsi kwayo ayinawuvezwa,
the identity of any other protected person and the place of safety or location where such person is being protected, or the relocation or change of identity of a protected person,
akunawuvezwa noma ngawungubani omnye olapho kolo khuselo apho ekhona uMr X noma kwindawo azawususwa ayiswe kuyo.
or D, any questioning of Mr. X which can lead to disclosure of any of the matters referred to in paragraphs A, B, and C. That's the 3 I've just read.
Nemibuzo ke ezakwenza kokuba kuvele esidlangalaleni kokuba ngubani lo muntu ayinawuvunyelwa.
That members of the public may listen to the audio transmission of the testimony of Mr. X in the overflow room,
Khoke iroom engale ekuthiwa i-overflow room apho abanye nje abangewona amaqela nababandekanya bavunyelwa kokuba bangene bamamele ubungqina buka-Mr. X.
that members of the media may not publish the name of Mr. X or any other information which may reveal his identity,
Nentatheli ke kazivunyelwa kokuba ziveze esidlangalaleni okokuba unantsika lo ekahlehle ngubani.
and 10, that all video recordings of the evidence of Mr. X must be blurred out so as not to disclose his identity.
Xa kuvezwe umfanekiso wakhe kufanele ucinywe ube mnyama kungabonakali okokuba ingubani lindoda.
I've decided to add a further ruling,
Ndiye ndacinga uba ndongeze nale nto ilandelayo ngoku,
which is as follows: that because the proceedings are, I understand, being broadcast, counsel shall not refer to the witness by his name during the course of his evidence, whether in chief or while he's under cross-examination.
ngesizathu sokuba obungqina buvezwa apha buyavezwa koonomathotholo nasezindabeni. Abameli xa bebuza imibuzo akufanelanga bambize ngegama isifani sakhe noma isibongo kudeske kuvele okokuba le ndoda unantsika kanti ngusibani bani.
Mr. Semenya?
The chairperson, also ex-Abundante Cautela, the statements which will be revealed on the website, where they bear reference to his identity, also ought to be redacted.
Redacted in such a way that his identity is not revealed, yes. I'll make a ruling to that effect also. Not only his name, but other material from which his identity can be ascertained.
Uyatsho kokuba umfanekiso ungavezwa noma ngeyiphi indlela uthi umgcini sihlalo ewe nisho kanjalo negama lakhe nebizo sifane nayo yonke into eza kumvezwa kokuba ngubani mayingapapashwa.
Some of the statements which we have been given indicate details such as his address and so forth, which obviously must also not be revealed.
We are indebted to you, Chair.
Yes.
Nestatement ezazibhalile apho abhale khona kokuba ungumuntu wakuphi ekuhlaleni asinawufundwa apha sifanelanga uba dizipapashwe nazo.
Mr. Mpofu.
Makasive umhlekazi uMpofu.
Thank you very much, Chairperson. I'm indebted to you and the commissioners for giving me this opportunity.
Enkosi kakhulu kuwe nakuba commissioner.
Let me say up front, Chairperson, that I appeal for a thorough considerations of the issues that I'm going to raise, because they are quite weighty issues which have been specifically instructed to raise before the evidence of Mr. X's head.
Icele ngaba abantwini bamele okokuba ndiyiveze lento endizawuyiveza ngokuyinto esindayo enesisinda ngako ke ngicela okokuba imamele kakuhle zikomishina nabo.
That is so, Chairperson and Commissioners, because your rulings on this matter will have material bearing on the nature and content of Mr. X's evidence.
Ndithetha lento mhlekazi ngoba isigqibo eneza kusenza apho sizawuba nokwenza nobungqina buka mhlekazi lo uNansika uX.
For lack of a better word, I'd call this a preliminary objection, in the sense that instead of raising the objections as and when the statements which I'm going to refer to are sought to be used, we thought it might be prudent and more time saving to raise the objection in a generalized fashion up front.
Ndibona okokuba mandiyiveze kusengoku lento yokokuba kuzawuboko apho sixhasana khona nestatement ezithise ezizawuvezwa ngendlela zizawuvezwa ngayo ngoku sibona ukuba masiyiveze kusengoku.
The issues in the objection, Chair, relate to documents which SABC has submitted as intended to be used in the evidence in chief of Mr. X.
Lento ke phathelene nestatement eziye zanikezwa nguSABC athi uzazi ukuziveza ekusebenziseni ukusika ubungqina bukamhlekazi uX.
And the broad issues relate to two interrelated concepts, Chairperson, of relevance and admissibility.
Ezike izinto eziphathelene nokuthi yamukeleka na loo nto phansi komthetho.
But before I deal with those concepts, I'd just like to paint very briefly the factual background of which brought us to this stage.
Phambi kokuba ndiwavezekela amanqaku mandithi ukondlalela ngalintetho endiza kuyibeka phambili.
Chairperson, as you know, we received last year Mr. X's statement without names, with the names having been blocked out.
Mandithi kulo nyaka ugqithileyo siye safumana istatement sika Mr. X igama lakhe nesifane kucishiwe kungaveli okokuba ngubani kahle hle lo muntu.
By the names, I mean the names of those people which he implicated or referred to.
Ndithetha ke nangamagama abo bantu bethetha ngabo ebaveza apha becimiwe nawo.
Eventually, last week we received the unblocked statement of Mr. X with the names contained.
Leviki egqithileyo ke xa kuvela okokuba ngobani kahle hle aba bantu athetha ngabo umhlekazi X.
This enabled us to consult for the first time with, at this stage, about 15 to 20 people, individuals who are mentioned in the statements.
Kuye kwasinika ke ithuba okokuqala ukuba sikwazi ukuba nothetha nabo bantu phakathi kweshumi nesihlanu kuya kubantu abangamashumi amabini abavezayo abangamabizo X.
Those consultations went on until quite late yesterday. We still have a few people outstanding, but that's not relevant for the purposes of
Besiloku sithetha nabo abo bantu kwaze kwafe izolo asikagqibi nangoku kusekhona abasele sezawuthetha nabo kodwa kuyongxaki leyo.
We also, Chairperson, had to wade through large volumes of paper which were supplied by SABC last week.
Safunda ke namaphepha amaninzi gqitha esiwanikezwe nguSABS kule veki igqithileyo.
In the course of the aforegoing, Chairperson, it is and relevant to what we are raising now. It has transpired that, one, there are confessions which were made by some of our clients in the context of criminal proceedings, which are pending before the criminal courts.
Kukho ke izinto ezizavela mhlekazi apho abantu abatshola ngamatyala athize olwaphulomthetho abo baye benza khona istatement apho bevuma khona amatyala asephambi kwekhoto kude kube ngoku.
And for the purposes of what I'm saying now, it will not matter much whether strictly legally speaking those statements amount to confessions or mere admissions. The point is simply that they are self-incriminatory statements.
Mandithi ke kuzawuthi ke xa sekufika elo xesha kubonakala okokuba zizinto ezivuma ityalana ikane nembavuma izinto ezithize kodwa ke ezo statement ziyababophisa aba bantu bazenzileyo bona ngokwabo ezizawusetshenziswa apho.
These criminal cases that I've referred to, Chairperson, involve very serious charges including attempted murder, arson, public violence and the like.
La manjala ndithetha ngawo ngamatyala anobuzaza gqitha mhlekazi amanye okubulala amanye azama ukubulala konela phansi inhlanhla impahla yabanye nokutshisa.
And in some cases the persons are implicated or implicate each other or implicate themselves in more than one such act of either murder, arson or public violence.
Intetho ezivela apha ngomnye waba bantu ozibophisa yena ikanene ozibophisa yena phinda fake nabanye kumatyala ohlukahlukile olwaphulomthetho onjengokutshisa izindawo.
In any event, to be clear from the commissioners, just from the nature of the kinds of issues we are dealing with in the commission, that such charges, as I have referred to, would in any event be serious charges.
Kuzawucaca njengoba ke izazivele ijaji nekommission okokuba la matyala aba bantu babhekene nawo ngamatyala anobuzaza ngenene.
It might well be important, Chairperson, to point out that there is a kind of direct relationship between those criminal cases and the proceedings of the commission.
Like the microphone's back on again, Mr. Mpofu, so you can continue.
Thank you, Chairperson. I was just busy with my last point on what I've called the factual background, namely that...
Before you carry on, may I say it's not necessary for us to have the picture of the Mr. X on the screen at the moment.
Yes.
It's
Manji-
gone now, and it can stay away until we need it. So carry on.
siza kususa umfanekiso kude kufika ixesha apho sidinga khona dingekile ukuba abe khona ngoku phaya emfanekisweni onantsika.
Thank you, Chairperson. The point that I wanted to mention was that, well, not some, all of the criminal cases that I've referred to, excuse me, including the big one of the 272 persons, have been postponed for trial pending the outcome of the commission.
Mandibeke ukuba ityala elikhulu nijongene nalo labantu abango 272 limile kwangoku lime okuba kwenziwe isigqibo kule commission.
Now, with that background in mind, Chairperson, the issue really, maybe just to jump towards the end, is to request the Commission or to uphold our objection to the use of the statements that I've described, and we'll supply a short list of the statements. They're not, but they involve about 5 individuals.
Manditsho okokuba isicelo sami okokuba ezo statement ezijongene naba bantu babekwe amatyala phaya zingasetshenziswa apha ngabantu angababahlanu mhlawumbe.
Right. Now, the legal basis, Chairperson, for this is I would like to start by defining what I've called the related concepts of admissibility and relevance.
Mandibeke phambili izizathu endizitshoyo okokuba zizo ezenza okokuba ndenze isicelo okokuba zamkeleke ngoluphi uhlobo.
At its most basic, as it is tried, Chairperson, that relevance simply means that evidence which is not relevant to the issues shall not be admitted.
Okokuqala into engabandakanya ezo zinto zabazibandakanye kolu phando lenziwa yile commission.
But in the broader sense, relevance has been described as, I'm reading from Zafet's book at 237.
Funda phaya kwincwadi yomthetho kaZafet.
It's the latest edition of
The latest, yes, the second edition, Chairperson, yes.
Yes.
South
What
African law
page?
of evidence.
What page?
Page 240.
Thank
Sorry,
South
I'm sorry, I'm
African
reading
law.
at 237 at this stage. 240 later.
Yawufunda amakhasi amabili 237 no 240 kulo ncwadi.
The introductory part says simply this, Chairperson, which is just a repetition of what I've just said. The criterion of relevance is applied to evidence in both a positive and a negative form. That is to say, it is generally true that relevant evidence is admissible and irrelevant evidence is inadmissible.
Beka ngolo hlobo mhle ukuba kuthiwa ubungqina obungaphathelene nabantu makungaziswa ngaphambili ngaphandle kokuthi bubambeka.
Each of these propositions will need some qualification, but before the two sides of the coin are examined in detail, something must be said about the meaning of relevance in the law of evidence.
Fanele kujongisise kakuhle okokuba ifanele na iphathelene naloo nto ivela apho kuleyo phepha nalo lo phando noma elo tyala kuthethwa ngalo.
Then under the heading, the meaning of relevance, the authors say the relevance is essentially a matter of reason and common sense.
Uthi ke apho kufanele ijongisise leyo nto kucingwe kakuhle ngayo.
As Schreiner J.A. said, it is, quote, based upon a blend of logic and experience lying outside the law.
Njengoba amajaji ke ayenza izigqibo zokuba kufanele kujongisise izigqibo eziyezathatha ngaphambilini okokuba zihambelana naloo nto.
The American Law Institute's Model Code of Evidence defines relevant evidence as, quote, evidence having any tendency in reason to prove any material matter.
Xa sijonga umthetho waseAmerica ke wona ubona ngenye indlela okokuba kufanele kube ubungqina obubonisa ngenyaninyani okokuba into ethize yenzekile iphathelene naloo nto kuthethwa ngayo ngelo xesha.
And so I'm going to deal with it, as I say, Chairperson, both in its narrow context and that broader context as explained by Schreiner in the American Code.
uthi uza kuzithinta zombili ke umhlekazi uMpofu njengoba uJudge Schreiner ezibeka kuwomabili amatyala athetha ngawo.
And if you allow me, Chairperson, just to read at 240 to 241 of the same book. It's not very long, but it will save a lot of time.
Andingafunda nje apha iqendu ezimbili 240 no 41 enawuthatha ixesha.
The authors here say relevance, as the law sees it or should see it, is a function of two variables of which logical relevance, quote, the tendency in reason to prove any material matter, according to the common sensible present-day standards based on experience, is but one.
Beka ngolo hlobo njengoba beyichazile okokuba mayijonge ngoluphi uhlobo ukuze kubonwe okokuba iphathelene nalento okuthethwa ngayo.
The other is the extent to which the reception of evidence is for various reasons undesirable.
Kwesibini ke ukuthi xa ingavezwa mhlawumbe ngezizathu ezithize apho ingafanele okokuba ivezwe khona.
The court will require a high degree of relevance before it will receive evidence which involves a lengthy investigation of collateral issues or is likely to cause prejudice or confusion or raise difficult questions of credibility or whose reception would materially involve any other serious disadvantage.
Uthi ke ikhotho noma mhlawumbe uphando njengolu kufanele licingisise nyani okokuba loo nto ngaphambi kokuba yamkele okokuba inako nakokuba ide idlele indlala omnye ngendlela ingafanele.
On the other hand, evidence which does not have these disadvantages will often be admitted as a matter of convenience, even though its relevance may be fairly slight.
Uthi ke xa kungekho kudlela indlala iyamkelwe into njengaleyo noma isisindo sobunqina singengako.
The test is essentially a practical one.
Fanele kujongisise okokuba ijonga ngoluphi uhlobo.
The court should consider all material which may help it reach a proper conclusion, but the value of some evidence is outweighed by the problems it creates.
Uthi ke ikhotho kufanele ijongisise ngoba kwamanye amaxesha isisindo sobo bunqina siye senzele phansi sidlele indlala inyani ekugqibeleni.
Balancing the competing considerations is, within the limits of fairly wide general principles, a matter for the discretion of the judicial officer.
Ngoku ke uthi ngoba ezi zinto zinokuchayisana kuye kuthi loyo ohleli ngaphambili ojonge kube uye kufanele enze isigqibo esifanele.
And it is therefore to that wide discretion, Chairperson, that we appeal in what is to follow.
Remember, the regulations for the Commission, in fact, specifically vest me with the power to exclude evidence, even if it is strictly speaking irrelevant, if, in my opinion, it doesn't contribute materially to the
That's correct.
Answering of the questions posed for our answer under the terms of reference.
That's correct.
So that strengthens the point that you made from the passage you read.
Uthi umgcinisihlalo ewe umthetho weCommission uyayivuma loo nto kuba ubungqina obungaphathelene naloo nto ephandwayo mabungathathwa.
Thank you, Chairperson. And for convenience, I might as well turn to that point then, because that was the point I was going to deal with. Indeed, Chairperson, in terms of the regulations regarding the Commission of Inquiry into the tragic incidents of to Marikana and so on, Regulation 11, which is the one that the Chairperson was alluding to, reads as follows.
Uthi xa sijonga ke imimiselo enikezwe le commission okokuba iluphande kanjani imi ngolu hlobo xa sijonga phaya ku page 11.
Whenever the commission is satisfied upon evidence or information presented to it that the commission's inquiry may adversely affect any existing, instituted or pending legal proceedings or any inquiry instituted in terms of any law, evidence which is relevant to such legal proceedings or inquiry shall be dealt with by the Commission in such a manner as not to affect adversely such legal proceedings or inquiry.
Ibeka kakuhle okokuba xa le commission yenza oluphando ke mayijongisise ezinye.
That's not the regulation I referred to. Of course,
Yes.
I'm aware of that regulation as well.
Yes.
And I can understand that regulation also has a bearing on the submissions you're going to make.
But yes, thank you, Chairperson. In fact, I was just about to say, in addition to the general discretion that the Chairperson referred to, this one is also of relevance.
Uthi kujongisiswa okokuba kungafakwa izinto ezizawuthi phaya ekugqibeleni zidlele indlala abantu kwamanye amatyala abazawujongana nawo kanti ubungqina buvezwe kule commission ngendlela engeyona.
Chairperson, I'm not going to waste time about the self-evident harm which might befall those people who may have made self-incriminatory statements. That it goes without saying. What I want to refer to, Chairperson, before I refer back to this to the regulations, is simply that our instructions, and we consulted on this very extensively yesterday, are clearly that the self-incriminatory statements that I've referred to were obtained by the use of very graphic torture. We have medical evidence in respect of some of the individuals concerned who were taken last year after their release to medical practitioners. I don't want to get into those details. No doubt those issues will feature one day in a trial, within a trial.
Can I interrupt at this stage and ask you this question? You referred to a number of statements which the SAPS have given you copies of, on which they intend to rely. Have you had the opportunity to consult with all the persons who allegedly made the statements to which you refer?
Not all, Chairperson. I think there's, in terms of this, I've obviously consulted with all the people referred to, but I assume you're...
That's what I meant, yes.
Yes. Well, Chairperson, let me rephrase that. I have requisitioned all the people who have been mentioned in the statements. I have so far consulted with about 13 to 15 of them. There are about 5 of them outstanding. But
just to make sure that you and I are understanding each other,
yeah.
I'm referring to people who allegedly made statements upon confessions, as you call them,
yes.
or possibly incriminating admissions, upon which the SAPS have indicated that they propose relying on these statements. All those people, in other words,
that category.
Have you consulted with all of those?
ubuzwa apha okokuba uye wathethana naba bantu ukuthi umthekazi Mpofu ezi statement ezizawusetshenziswa apha ngamapolisa ndiye ndathetha nabantu abazenza kwaba ndibamele abanye nobungqina obuvela kumagqirha ukuba aba bantu babebethwe ngendlela emasikizi xa bezokwenziswa ezi statement andikathethi nabo bonke kodwa kusosele abahlanu.
There's only one in that category who's outstanding, Chairperson, but I've consulted with five of them in that special category. Yes.
Hlanu kwabo kusele omnye ngoku.
Let's give Mr. Mustangi a chance. I'm sorry. Karen.
Thank you. Just finished.
So what we're really talking about is 6 statements, which are either confessions or self-incriminatory admissions,
Sure.
which you contend are inadmissible because they were extracted improperly,
Yes.
and which would be not received in evidence in a criminal trial because of the factor upon which you rely. And 5 of the persons you consulted with, and 5 of them have alleged to you that the statements were extracted from them in the circumstances such as you've mentioned. There's one person outstanding with whom I take it you're still hoping to consult. Is that correct?
Uthi kwabahlanu aba bantu asethethe nabo kude kube ngoku umthekazi Mpofu kuye kwacaca okokuba aba bantu banyanzelwa okokuba benze ezi statement kukho nobungqina obuvela kumagqirha.
Chairperson, without revealing too much, I would say instead of 5, say 4. Though there's one where there's a grey area. 4 of the 5 have certainly made allegations.
So there's 6 statements.
Yes.
You've consulted with 5 of the persons who made the statements.
Yeah. Of which
4 of them positively state that the statements were extracted from them in circumstances which would render the statements inadmissible.
Yeah.
There is what you call a grey area in respect to the 5th,
Yeah.
and you're still endeavouring to consult with the 6th.
That's correct. Yes.
Ukho abahlanu esendiye ndathetha nabo
I don't want you to say something in public which could
Yes.
be embarrassing for the persons, but I'd be grateful if you give me possibly in writing during the adjournment the names of the 6 people to whom you refer, I don't think it's advisable to get into the public domain that these 6 people allegedly made confessions if, in fact, those confessions aren't admissible. But if you can give them to me in writing, and obviously to Mr. Matapedi and Mr.
Thank you,
Semenya,
Chairperson.
that would help.
I appreciate
enkosi
that.
kakhulu uthi umgcinisihlalo makanikeze umhlekazi uMathibedi amagama alaba bane athi akanangabazo kokuba babenyanzelele kokuba bazenze ese statement. Uthi enkosi kakhulu.
Thank you very much, Chairperson. Yes, in fact, if I may remind the Chairperson, some of these people we referred to along the lines that the Chairperson has said last year, shortly after their release, when we were complaining about their torture and so on, in broad terms, without mentioning their names.
Uthi umhlekazi uyewababona abantu kulonyaka ugqithileyo xa sibaveza apha bekhalazela ngokuphatha kwabo emva kokuba bakhutshiwe.
Safe to say, Chairperson, that Chairperson will remember that one of those persons had alleged that he had been assaulted until he soiled himself. Another one said that his eardrums were severely affected. I've not looked at the medicals again. And that kind of, those kinds of allegations which are already on the record.
Wamosha ibhlukwe uthi omnye ubethe akaseva nakuhle apha ezindlebeni obomnqina bukhona apha phambi kwale commission.
So that's the kind of allegations we dealt. As I said, Chairperson, I don't want to dwell into those things. They might well be they feature in trials within a trial in the criminal cases at a later stage. But just broadly, those are the kinds of allegations.
Xa kuqhutyekwa ngala matyala zizawuvezwa ezo zinto kodwa ndibona okokuba mandisiveze nalapha kuwe mhlekazi njengezinto ezifanele okokuba uzazi.
Now, Chairperson, before I deal with the factors which might be relevant to the discussion that I've referred to, I just wanted also to specifically deal with what I call relevance in the stricter sense rather than the wider sense. Namely this, Chairperson. In weighing up the issues, I'd like the Chairperson to take into account whether, in fact, the question of assuming the statements were not even extracted in the manner that I've alluded to, are there contents in respect of self-incrimination and so on actually relevant to the issues that the Commission has to determine?
Mandibeke ngolo hlobo kokuba noma xa sithi mhlawumbe thikelelo kokuba zishunyelele indlela state ngendlela eright apho abantu bazibophisa khona ziphathelene na ezo statement nophando olwenziwa ile commission masijonge ngolo hlobo lento.
And I know that, Chairperson, at face value, this submission might sound strange in the sense that obviously the Commission has to determine what happened during that particular period and so on, and also the such quote-unquote confessions stroke admissions would be relating to exactly the matters that happened in that period. But that is not the sense in which I'm raising this point.
Mandithi ke nyani kungumsebenzi wale commission okokuba iphande kanzulu okokuba intoni eyenzeka ngolo hlobo intoni eyabangela ukuthi nokuthi kodwa ke mandiyibeke kanjalo.
I'm raising this point, Chairperson, in the following manner.
Iveza ngolu hlobo mhlekazi lento.
It is not the function of this commission to pinpoint specific criminal liability on the part of specific individuals.
Mr. Mpofu, is that entirely correct? Among the terms of reference is a request to us to consider suggesting to the Director of Public Prosecutions that prosecutions be considered against particular individuals. That would possibly include suggestions in respect of members of the police service if they have behaved in a manner which would constitute a criminal offence. Equally, of course, the same point would apply to some of the strikers if the evidence reveals that they may well have committed criminal offences also. So I'm not sure you're entirely correct in saying that that's beyond our province. It certainly is an aspect we have to consider.
Yes.
Umfundela apha kwimimiselo yekomishini apho kuthiwa khona xa eminye imisebenzi yale komishini ukuthi xa kufanelekile likomishini iza kudlulisa imicimbi ethize igqithele kubatshutshisi okuzawuba ngabo ke bazokwenza okokuba kwenziwe uphando kujongwa okokuba kuye kwabakho ulwaphulomthetho na.
Yes, thank you, Chairperson. Knowing you, I anticipated that question. The issue, Chairperson, is as follows. Let's take, for example, I'll answer it indirectly first. One of the reasons, Chairperson, that, for example, we have been told that the shooters, as we call them, are not going to be all called here individually to say, this is why I shot and this is how I shot and so on, is exactly because whatever the criminal liability of those shooters is a matter that is separate from what the Commission is investigating. What the Commission is really investigating principally is whether there is liability on the part of groups of people, generically speaking. So when you look at the terms of reference, and I won't read them, you'll see, for example, the Commission shall inquire, make findings, report, and make recommendations concerning the following, taking into consideration the Constitution and so on. One, the conduct of Lonmin, and then it says the conduct of Lonmin PLC, not of Mr. Sinclair or Mr. this and that. And then the conduct of AMCU, and then the conduct of NUM, and so on and so on.
Uthi umhlekazi Mpofu ndiyayiva loo nto umhlekazi ukuba njengoba sivile okokuba aba badubula abanawubizwa bonke bazochaza okokuba yintoni nantoni into oyiphandayo okokuba iqela neqela elibekwa apha lenza ntoni eyayingekho emthethweni njengoba kuzawuphandwa uLonmin kuphandwa uAMCU kuphandwa uNUM nabanye.
And the two provisions which are not, don't fall into that generic category, which might be a more direct answer to your question, Chairperson, are 1.6. Firstly, 1.6 says one of the things that the Commission must investigate is the conduct of individuals and loose groupings in fermenting and or otherwise promoting a situation of conflict and confrontation which may have given rise to the tragic incident directly or indirectly. So it's confined to the fermentation of a particular atmosphere when it comes to that category.
Oluphando lakho mhlekazi xa ujonga phaya ku-1.6 abolujonge khona nomuntu ngamnye lifundeka ngolo hlobo kokuba mawuphande ukwenza komntu ngamnye ngamunye namaqela okokuba yintoni ayenzile eyaphembelela oludushe oluyabangela lintlekele.
And then, Chairperson, paragraph 5 of the terms of reference, which is the one that the Chairperson referred to, says, the Commission shall, where appropriate, refer any matter for prosecution, further investigation, or the convening of a separate inquiry to the appropriate law enforcement agency, government department, or regulator regarding the conduct of a certain person or persons.
Apho funda khona mhlekazi lapho ifundeka khona le mimiselo okokuba xa likomishini ingenza izindululo sokuba idlulise lo mcimbi ubudlulisele kubatshutshisi kuba ngabo abaza uphando kokuba kukho into efanele kokuba iphandwe ngabanye amanye amaqela kahulumende ikane nentoni.
Now the paragraph 5, Chairperson, exactly postulates a situation where the Commission would make a referral for, let's say in this context, a criminal prosecution.
And esesihlanu ke sithetha ngalonto apho uzokwenza khona mhlekazi isindululo sokuba makuphandwe iqela noma umuntu othize igqithisele kumnye ozokwenza uphando lohlukile kunolu lwakho.
it does not, firstly, postulate where the Commission itself must busy itself with the determination of such criminal liability.
ayisho kokuba kufanele isigqibo sokuba lo muntu nyani unetyala masenziwe yile commission yona izogqithisa eso simdululo.
And secondly, Chairperson, and more importantly, in the case of all the individuals who fall into what we've called the special category,
Andithetha ke ngaba abantu ndithetha ngabo ngithi bave ba kwelo qela.
criminal proceedings have already been instituted.
Sebebekiwe aba bantu bebekiwe amatyala bathwese amatyala.
So paragraph 5 in respect of those individuals is irrelevant because the Commission is hardly going to refer them to criminal prosecution when they've already been prosecuted.
Wesihlanu akukho nto ezoyenza le commission ngoba eso sigqibo sasithethwe njengoba aba bantu sebebekiwe amatyala.
Now, that being so, Chairperson,
Akunjalo ke?
and looking at it from the point of view of remember where we started, of the weighing of the prejudice versus property value and so on.
Sijonga ke phaa ekuqaleni abo besijongisisa khona yonke into imeko ezohlukahlukile.
It would mean that either at best for my argument there is no property value of the evidence, or at the very least it is there but it's tenuous.
Ngokubona kwami ke obubungqina abuna kuba nanto enokwenza.
And weighing that against the substantial prejudice and harm which is self-evident, which would be suffered by the individuals concerned, then I would appeal for the Commission to exercise its discretion in favor of excluding the evidence.
Aba bantu njengabantu abanento yokwenza ngaloo ndlela ibadele indlala phambi kokuba kungene amatyala abo.
So that sorry,
I'm sorry to interrupt you, Mr. Wolford. Mr. Korte made a point to me which I think I'd like to put to you. When you give us the names of the people on a piece of paper, which we've discussed not desirable to do in a public forum like this, it would be also helpful if you could tell us the charges which have been brought against those particular people. Because clearly your point would be that if one of them has been charged with the murder of Mr. Twala, for example, then we don't have to recommend that should happen because it's happening already. But if, of course, he hasn't been charged with the murder of Mr. Twala, and the evidence indicates that there is a strong case against him, then that would be a factor that would not be covered by your argument. So it would be helpful if you could give us then not only the names, but also the charges which have already been brought against them, because that would have a bearing on the application of the argument that you've just put.
Yes, of this particular argument, yes, Chairperson.
Uyiveza ngolo hlobo umhlekazi uDokotela xa ebeka ku-commission okokuba xa umhlekazi Mpofu angabanika emaphepha kube ngabo abajonga ukuba ongubani nobani okela ngetyala lokuthi wenza oku noku kungavezwa esidlangalaleni bazokwazi ukuthi lo ongakatshola ngaloo nto xa kukho isigqibo ekufanele basenze noma isindululo senziwe.
So to round off that point, Chairperson, on that leg of the argument, what we are simply submitting is that in the weighing up process, the prejudice outweighs, even if we concede to some tenuous property value, which might or might not be there.
Mandithi kapha ekugqibeleni njengoba siyivezile le nto inako ukwenza njengoba ndiyibeka.
The next point, Chairperson, which we would appeal for you to consider is also is a very important issue of consistency.
Enye into ebaluleke gqitha ililandelayo umhlekazi.
And I've already alluded to it in the context of what I call the shooters.
Ndike ndayiveza xa ndithetha ngaba abangabadubuli.
I won't repeat it, Chairperson. It's the same point that I raised in respect of the shooters and how the shooters on the other side would be treated in a way.
ke ndavezwa okokuba aba badubula bona bajonga ngeyiphi indlela.
If I can put the point to you as it appeared to me from the very beginning of this commission, to see whether it's the point you're making. The matter of general policy, it wouldn't be advisable for this commission to make positive findings of guilt against particular individuals. Because if the prosecution authorities decide not to prosecute them, or if they were prosecuted and acquitted, they would nevertheless bear the stain, as it were, of a positive finding of guilt by this commission. And that is a matter of general principle would not be desirable.
Yeah,
So
that's
it may well be we could find there's a prima facie case or something of that kind, but positive findings of guilt I do not understand to be within our terms of reference. And I can understand very powerful reasons of principle why we should refrain from doing that.
Yes. Thank you very much, Chairperson. And as a reference to that particular constraint, Chairperson, you'll remember that even I, at my most accusative or combative.
I think accusatorial.
Accusatorial.
Accusative is more of an adjective word.
It's better, yes. Would have said, Chairperson, for example, with regard to Brigadier Khalid, that we will recommend to the Commission that the Commission must refer your case for prosecution. I could never have said, put to him that, well, because of this or that concession that you have made, we're going to now ask this Commission to say you are guilty of anything. And that was because of that very constraint, Chairperson.
Unthi nakuye umhlekazi uMpofu njengoba beyibeka xa ethetha noKalesi ubengeka atsho apho kokuba uzawubekwa ityala elithize wena njengoba kufanele eso sindululo senziwe yile commission phaya ekugqibeleni.
Now, the next point, Chairperson, is simply the fact that, and this has also been made, this point has been made before, insofar as it's not clear to me, I must confess, how SABC, in any event, were seeking to introduce those so-called confessions through the evidence of Mr. X. But I'm sure that's a matter which they've thought about. But assuming that there was a way to do so,
Unthi umhlekazi akazi kokuba uyicinge ngoluphi uhlobo isaphi sokuba kube ngeyo eveza as a statement isiveza ngomhlekazi lo uNantsika mhlawumbe bacinge ngenye indlela andiyazi.
the potential prejudice, I can't put it higher than that, should also take into account that Mr. X is a self-confessed multiple murderer himself.
Makujongisiswe ke okokuba umhlekazi lo X ngumuntu onjani ungumbulali oye wavuma yena ngokwakhe okokuba ubulele amaqeka.
And his motives are still going to be revealed, no doubt, under cross-examination.
Usezawuvela ke injongo zakhe okokuba ubulala nje bekwenzeke ntoni nantoni.
But whatever they are,
Noma kuzintoni injongo zakhe zokubulala,
the extent to which he implicates others in gruesome and serious crimes, to say the least.
indlela ke aveza afaka nabanye abandakanya abanye kwizenzo zakhe ezinobuzaza.
Ought itself to be taken from whence it comes.
Fanele ijongisiswe apho ivela khona.
And to the extent that he, by his own admission, is a tainted type of witness.
Jongisiswe nokuba yena lo muntu ulingqina elinjani apha ebomini.
To that extent, the protection of others who may be innocent, or at least who claim innocence, unlike him.
Ke ukhusele abanye abathi bona hayi abanatyala njengaye ebomini.
Should be taken into consideration.
Jongisiswe kakuhle lo.
The last consideration which we would appeal for the commissioners to take into account in the exercise of the discretion
Enye ke into esizama ukuba sicela apha kwi-commissioner ukuba sijongisise yile.
is that in any event, broadly speaking, in our law, pre- and post-constitutional dispensation, the right to against self-incrimination is one that is always jealously guarded in our system.
Masijonga umthetho wethu phambili nasemva kokwenziwa komgaqo-siseko lo okhona eligunya lokuba umuntu makakhusele ukuba angazibophi yena ngokwakhe ligunya elikhona elikhusele.
And without going much into detail, because the content of that right is quite trite.
It's constitutionally entrenched.
Yes, it's constitutionally entrenched, and as I said, it even existed even before that.
Umgcinisihlalo likhona libhalwe phansi kwi-constitution ukuthi uMhlekazi Mpofu naphambi kokuba ibhalwe i-constitution beliloku likhona.
I would simply want to refer you, Chairperson, to page 582 of ZEFET.
Andiye ku page 582 kuleyo kumlomqulu ndiwuphethe apho kubhalwe khona ngolu hlobo,
where it deals simply with the question of the scope and applicability of the right, as follows.
kuba eligunya libanzi kangakanani.
As we mentioned above, our courts have accepted that the privilege is not limited to criminal or civil proceedings.
Umthetho uthi akukhusele kuphela abo babekwe izehlakalo zolwaphulomthetho.
It is available, for instance, to a person called as a witness in inquest proceedings.
Umuntu obizwe njengengqina mhlawumbe apho kuphandwa khona ngokusweleka komuntu ukhusele ngalindlela.
And it seems in administrative and quasi-judicial hearings.
Lisetshenziswa ke kuzo zonke indlela zomthetho ezohlukahlukile.
The simple point being that the right against self-incrimination would be applicable in proceedings such as this one.
Okubonakala okubana kuphando olunjengolu elo gunya likhona.
Yes, Chairperson, I think those would be the specific considerations which we would highlight. The list is not exhaustive as to the exercise of the discretion that we seek to be.
Iphelela apha ke Mhlekazi ngamanqaku benithanda ukuba ndiwaveze noma ndingavezanga yonke into kodwa ndiyophelela.
So all in all, Chairperson, the ruling we seek is for the exclusion
Sicelo sethu kokuba bungafakwa
of statements pertaining
the statement
which are A, self-incriminatory and or pertaining to persons who claim that
No, B. A,
yes,
self-incriminatory,
yes,
or B,
and or B,
and or is.
yes.
sicelo ezimbini kokuba kungathathwa i-statement apho umuntu ezibopha yena ngokwakhe noma omnye ebopha omnye.
Finish pertaining to?
Yes, sorry, Chairperson. Now I've lost my sentence, which I had just crafted. Pertaining to persons who claim that such statements were improperly obtained. I'm just giving it in a generic kind of feel.
Ingakumbi xa lo muntu wenze eso statement azisafunyanwa ngondlela mnyama.
Maybe I might add, Chairperson, just that's the order. Just something that I forgot to mention.
Improperly obtained, you mean in circumstances which would render them inadmissible in the court of law?
Exactly, Chairperson. In circumstances where they would prima facie be inadmissible. Obviously, we don't have the facility of a trial within a trial in these proceedings. So one can postulate.
Ndithi ke i-statement ekunokwenzeka okokuba xa sekuyiwa ekhoto apho zingenza ukuba zingamkeleki khona.
What exactly do you mean by exclusion?
Okay.
The reason I asked the question is we've received some bundles from the police which include dockets. Now these dockets include all sorts of statements, including the statements to which you refer. Now, and all sorts of other statements as well. Now, do you submit that the exclusionary order you seek should be wide enough to involve the removal of statements of that kind from the dockets that are before us?
Yes, Chairperson. And one of the reasons for that, Chairperson, is a point which
Don't let me get that down.
Sorry.
You say
Okay, Chairperson.
uyachaza apho umhlekazi okokuba banikwe imiqolo ethize phakathi kwawo koko idocket ezathetha ngazo umhlekazi Mpofu. Ngoku kwisicelo sakhe ucela okokuba ezo statement ziphakathi kulawo madocket kuba zizo ezingafakwa na kolu phando lakhe uthi ewe.
Yes, yes.
Yes, Chairperson, I just wanted to make
I take it this order is made in relation to the 6 people on whose behalf whose names you're going to give to us in writing.
That's correct, Chairperson, but I might just mention, that's why I use the word statements instead of the persons, because some of the persons might have made one or more statements.
Yes, no, I
Yes.
understand. All statements made by
Those
the 6 persons to whom we refer
That's correct, Chairperson.
Aba bantu basithanda
allege, or
ukuthetha ngabo.
in the case of the 6th or possibly even the 5th, allege that the statements were obtained in circumstances which would render them inadmissible.
Yes.
Yeah.
Uthetha ngezo statement mhlawumbe kungenzeka ukuba umuntu angamnye enze ezimbini noma ezintathu kodwa ke sithetha ngaba bantu abasithandathu abaveze aba bazawunikezwa amagama abo abhaliwe.
Chairperson, if I can just mention just 2 quick points. One is that the dockets concerned, or rather the statements concerned, were obviously obtained for the purposes of different proceedings to the current ones.
Mandithi ezi statement ke lawo madocket avulela ezinye izizathu ezingaphathelene nale commission.
And as the Chairperson has correctly alluded, their admissibility or otherwise will probably be determined in those proceedings.
Mandithi ke ukwamukeleka nokungamukeleki kwazo isigqibo siyokwenziwa apho zizosetshenziswa khona ezo docket.
The next point which may be of relevance is the fact that, at least in the case of, I think, 2 of the individuals, they indicated that they had wanted the presence of ourselves as their legal representatives, which was denied.
Mandithi ke ababini babo bayatsho kokuba bacela kokuba abameli babo babe khona apho xa benza istatement banganikwe lokhu.
Again, I'm just mentioning that blandly, Chairperson. It's a matter that will be dealt with at the appropriate time.
Let me make sure I understand you. This sounds like a second alternative ground of admissibility. Either the statements were extracted by force, or the threat of force, or even if there wasn't actual force or actual threat of force, the taking of a statement in the circumstances was inappropriate and therefore inadmissible because the right to legal representation which was requested was not accorded to the person who made the statement before the statement was made, and that you would contend in the alternative, as it were, was in any event would be a basis for excluding the statements in a trial, and ergo you say they should be the basis for the exclusion of the statements here.
That's exactly correct, Chairperson. That's why I use the word generically improperly, but it would encompass those 2 examples.
Njengoba ndisitsho mhlekazi okokuba uyawuthi phaya iveze le nto okokuba noma lungaveli unyanzelo kwaba bantu ababili kophulwa umthetho apho bangavunyelwanga khona okokuba babe nabameli babo njengoba baqelile phansi komgaqo-siseko welilizwe.
Thank you, Chairperson. Those are the submissions.
Thank you, Mr. Mpofu. Who is going to reply on behalf of the SABC? But perhaps I should also state that I am proposing to ask the evidence leaders as well, but I think after we've had a reply from the SABC. I was proposing to take the adjournment at about this stage. If you prefer to argue after the adjournment, I'll let you do that. If you'd like to argue now, I'm in your hands.
It would be convenient to do it, otherwise it's going to be an argument that is interrupted by the adjournment.
All right, thank you. Adjournment for 15 minutes.
Sizawuthatha ixesha le
resume
15 minutes. Niyakhunjuzwa nime ningahambi kuze kuphume ii-commissioners.